Okay, we're gonna get started. Okay, thanks everyone for being here. My name is Max. I'm the Symposium editor for California Law Review. I'm just gonna start off by reading a land acknowledgement. California Law Review recognizes that Berkeley sits on the territory of Ushin, the ancestral and unceded land of the Chochenyo Ohlone, successors of historic and sovereign Verona Band of Alameda County. This land was and continues to be of great importance to the Ohlone people. Recognize that every member of the Berkeley community has and continues to benefit from the use and occupation of this land since the institution's founding in 1868. Consistent with our values of community and diversity, we have a responsibility to acknowledge and make visible the university's relationship to Native peoples. By offering this land acknowledgement, we affirm Indigenous sovereignty and will work to hold the University of California, Berkeley more accountable to the needs of American Indian and Indigenous peoples. In recognition that California Law Review benefits from this history, we pay the Shuni land tax as a small way to contribute to the healing of this history, sovereignty of the Ohlone people, and the preservation of their culture. I want to thank everyone for bearing with some logistical changes to the event today, and in particular, thank John from the Brennan Center and Nancy from UC Berkeley for agreeing to record this event for folks that can't make it today. As I said, I'm Max, and I'm the Symposium editor for the Law Review. I'm also a member of UAW 2865. That's the union that represents graduate student workers across the UC system. I just want to bring this up to explain that we're in a smaller room today, in part because the union is on strike, demanding a fair contract with the university. Campus workers who teach classes and perform research for the school are asking for wage increases that reflect the high and rising cost of living near UC campuses, which are some of the most expensive areas to live in California. Despite the 48,000 worker strike and 98% of union members voting to authorize it, the university system has so far been slow to schedule bargaining sessions and unwilling to make meaningful concessions on key terms. Now, on behalf of the California Law Review, I want to say that we're honored to help present this event each year as the West Coast hosts of the Brennan Center's tradition. Not only do we get to host the event, but we also have the honor of publishing pieces by the speakers each December. Around this time last year, I sat in my kitchen in front of my computer screen watching Professor Stephen Levitsky deliver his lecture online. Now, as we get ready to publish his speech and the commentaries stemming from it next month, I'm excited to launch the next cycle with Professor Blight, Professor Gordon Reed, and our own Professor Tomlins. Also, as a student nearing the end of the semester, I think today's topic presents a nice opportunity to stop thinking in outline and IRAC format for a moment and consider the historical backdrop of the law that we all work so hard to understand. With that, I'll turn it over to Dean Chemerinsky for further introductions.
Thank you, Max. Thank you all for coming back, and for all who are watching the recording. Thank you for doing that. The Brennan Center Jorde lecture is very special. It was created in 1996, named by the Brennan Center for one of its donors, Jorde, the clerk for William Brennan. It's meant to present varying perspectives on important issues in honor of the memory of Justice William Brennan. And it is unique in that it's a lecture that's given twice each year, once here at Berkeley and once at another law school in the spring. This year will be delivered at NYU. And each time there are a pair of commentators that are different in each of the two locations. And another wonderful aspect of this, as Max alluded to, is that the California Law Review will be publishing this, and will be publishing the December 2023 issue. We could not have better speakers for this. And I want to, at the very beginning, thank Tom Jorde for all of his wonderful financial support for this over the years. And I want to thank the Brennan Center for their partnership. Especially want to thank John Cowell, who's here with us today. He is so much the driving force for this happening each year. I believe that no one comes to an event to hear the dean's welcome, hear the introduction of speakers. And I could spend all of our time telling you the terrific qualifications of the speakers. What I'm going to do instead is do very quick bios or detailed bios, of course, are available online. And then I'll also play the important function of welcoming you to a reception that will occur out in the lobby at the end of this. And I have the benefit of what I'm going to say being right behind me on the screen, which means I can even be more read. Our primary lecturer, as you see, is David Blight, who's the Sterling Professor of American History at Yale University. He's the author of a much acclaimed book that came out just a few years ago and received much praise. It came out in 2018 and it's titled Frederick Douglass, Prophet of Freedom. And Professor Blight is going to be talking to us today about Frederick Douglass and his perspectives on the Constitution, an additional perspective reading slavery very much as part of the fabric of the Constitution, and then later looking at the Constitution from a quite different perspective as an opportunity for remedying discrimination and the legacy of slavery. We have two wonderful commentators. Again, you can see their names behind me. Annette is the Carl Loeb Professor of History at Harvard University, also a much acclaimed author. And we're fortunate to have our own wonderful colleague, Chris Tomlins, who, as you can see, is Elizabeth Josselyn, Boalt Professor of Law here at Berkeley. You too, the author of so many books and so many book prizes. So with that, I'm going to get out of the way. The only other thing I'm supposed to say is when we're done, there is a reception there. Please join us for that informal conversation. With that, I'll turn it over to Professor.
Thank you, Mr. Dean. And thanks to Robert Post, my colleague at Yale, the former dean of the Yale Law School, who first invited me to do this. Bob Post is one of those people I can't say no to. Thank you, John Collins, for sort of shepherd this project all along. Nancy Donovan shepherded me here. And to Annette, my old friend, Chris Tomlins, my good friend, for agreeing to do commentaries. I've already read Chris's and sent it to him. I'm scared, but not really. And that I've come to totally trust. I'm loosening them up a bit. I want to begin simply with this. Clarence Thomas, Justice Thomas, has a very large portrait of Frederick Douglass in his chambers, the Supreme Court, right above his desk. Just wanted to mention that fact. He has a very selective view of Douglass. But right after my book came out, one of his former clerks wrote to me and said, Justice Thomas would love to have a signed copy of your book. So I did. I signed it with great respect and so forth. Just last week, I had a request from not a clerk, but some friend or some associate of the new Justice, Ketanji Brown Jackson, asking for a signed copy of the Douglass biography. My inscription was a bit longer on that one, and I don't mean that with any harm, except it only shows how completely malleable and contradictory Frederick Douglass can be, depending on how we read him. A little bit like the Constitution itself. Douglass was, of course, born a slave, out on the eastern shore of Maryland. He spent 20 years, first 20 years of his life in bondage. He had absolutely no conventional education. I start with that because we're working ourselves here, of course, toward a man who became an extraordinary intellectual and a serious thinker about the Constitution. How can that be? His education came from people around him, from books, from journalism, from wide reading, and finally from his personal experience and his relationships. Douglass was with time an intellectual sponge. If he met you, he'd figure out what he could learn from you. Whether you were a Thomas Clarkson, whom he met almost on his deathbed in England in 1847, or an Abraham Lincoln in the White House, or a John Brown in an old stone quarry, or an unnamed half-clothed fugitive slave escaping through his house in Rochester, or feminist abolitionists like Abby Kelly, with whom he shared the road as an itinerant lecturer for 2.5 years. Whomever he met, he figured out what he could learn from him. And often when he thought he had learned what he could learn, he tended to discard people, which is why he didn't keep a lot of friendships. He made friendships, as well as a lot of rivalries, that provided him extended forms of education, mentorship, sources of books, even lessons in human nature from his oppressors. From the educated classes in America and in England, he drew knowledge, confidence, advice, personal financial support, a lot of it, a book collection, and even competitive spirit. Slaveholders themselves were his unwitting teachers. Now, in this paper, the longer paper that may not be published if it passes muster, I have 4 sections. I try to do at least 4 things. First, I'll try to condense these today. The first is to try to show or demonstrate Douglass's schooling, we can use that term, in the natural rights tradition. Not from reading at first, but from experience. The second is his transformation from a believer in the pro-slavery Constitution, a thorough Garrisonian as he came of age in his 20s and into his early 30s. But his transformation between roughly 1847 and 1852 into an anti-slavery constitutionalist. And by the end of the 1850s, one of the most vehement. The third little section is about Douglass and text and intention, those words we hear so much in constitutional discourse. He did become a textualist, and he really was concerned about intention, depending on when and who and about what. And lastly, this idea of 2 or 3 or multiple constitutions. Douglass went through at least 3 in his life. At least 3. Now, his schooling in natural rights, his roots in bondage and slavery, his lack of an education became a constant feature of his self-representation and his writing and his rhetoric. It was kind of an opening witness in so much of his autobiographical writing. He would start speech after speech after speech, even into his later years, by always telling his audience that he had no education. Why someone like me here would ever set foot a day in school, which was always his false modesty setting up an audience. I do not forget that 32 years ago, I was a slave, he remarked in 1870, within an hour's ride of this capital where I now am. I do not forget that on the wharves and in the shipyards of Baltimore, I studied my first lessons in spelling and took my first lessons in writing. From the time I learned to read and learned the value of knowledge, it was among the deepest wishes of my soul to assist in the deliverance of my people, not only from slavery, but from the more terrible bondage of ignorance. Douglass, many times over, whether in autobiographies or speeches or editorials, would stress that the greatest threat of slavery was not to the body, to the mind. Its capacity to create ignorance. Now, he prided himself in being the self-made man, but fundamentally, I don't have time to go into all of this here, he was not a self-made, educated man. Of course, it took tremendous self-will on his part to read and read and read as he did. He had help. He had mentors, and he needed a lot of them. He had a variety of mentors at different stages of his life. The first major one was William Lloyd Garrison, the radical prophet of immediatist, moral suasionist abolitionism. founder of the American Anti-Slavery Society and the Liberator, the longest lasting anti-slavery newspaper. There's a tendency now in the study of abolition to cast Garrison into some background role, some negative role, kind of always standing in the way of the emerging greatness of Frederick Douglass, which is largely nonsense. Without Garrison, Douglass wouldn't be Douglass. But he did have to get rid of Garrison. Garrison was, at base, he was essentially an anarchist and a moral, biblical perfectionist. He didn't believe in voting, he didn't believe in political parties, he believed in this rather arcane and confounding idea of no union with the slaveholders, disunionism as he called it, not being complicit with the immorality of slavery and therefore not participating in political life at all, even though Garrison was enormously political in what he wrote about. Douglass was never comfortable with the kind of anarchist edges of abolitionism, not because he wasn't as radical as his fellows, but what he was uncomfortable with was the perfectionism. Don't soil yourself with complicity with slavery. A fugitive slave, which is what Douglass was, and most Black abolitionists, not all of them, because there were some staunch Black Garrisonians, most former slaves who became abolitionists were far more pragmatic. They had to be. They needed more strategies that worked. Garrison believed radical abolition should resist electoral politics and voting itself. He was a strict pacifist. This "no union with the slaveholders" slogan looked good on a masthead of a newspaper, but not so good in action. The system of slavery one day was supposed to collapse under the ethical assault on the human heart and a rising tide of moral awareness, and desire to free individuals and the nation itself from the curse of slavery. Among Garrison's fiercest claims, and a strict tenet of those who followed him, was the pro-slavery view of the Constitution. Douglass was a believer, completely, for the first 5, 6, maybe 7 years of his public career. Garrison considered the Constitution an abiding buttress of slavery through the claim of humans as property, especially in the calculus of the 3/5 clause, the pledge to defend states against insurrection and assist the capture of fugitive slaves. He viewed, this is Garrison, he viewed the variety of compromises, of course, with slave states, as well as the very system of checks and balances, as its fatal flaw. And famously, as early as 1843, he called the Constitution a covenant with death, an agreement with hell. Garrison even exceeded the pro-slavery constitutionalist ownership of the meaning. He exceeded the ownership of the 5th and 10th Amendments to the pro-slavery constitutionalists. He also agreed with it that slavery followed the American flag anywhere it went in the high seas. As early as 1832, when Douglass was a 14-year-old in Baltimore, studying the Bible with an old storefront religious man named Charles Lawson, and collecting his first newspaper clippings about anti-slavery petitions in the North, Garrison had attacked John C. Calhoun in the nullification effort in South Carolina by demanding that Northerners cease all allegiance to a document like the Constitution, which he said is dripping with human blood. Douglass loved this rhetoric when he first read it. His adult perceptions of the Constitution began in those sentiments, not unlike some notions peddled by those today who see America as a place that is and has always been trans-historically racist to its legal and moral core. The very young Douglass, though, was impressionable and quickly susceptible to the idea that pro-slavery America was rotten at its constitutional beginning and made more so by historical practice. It seemed a logical history at first, in line with his experience of all the thoroughly legal horror wreaked upon him and his fellow slaves in Maryland. An inhumane system so unchecked by law had to be sustained by inhumane law. But as he became a man of language, a wielder of words, the only real weapon Douglass ever had, words, he became a kind of prose poet. And though he needed a more far-seeing analysis, a way to hopefully see law as an aid, and not always an enemy, especially after digesting the Declaration of Independence and breathing in from its creeds, the natural rights philosophy, which he now also discovered had been part of his everyday world while he had been a slave. Within several years, Douglass began to hone his belief in the natural rights tradition, a philosophy he came by even while he was a slave, into essentially a worldview that demanded much more from law, from politics, and principles. America's founding documents, the Declaration and the Constitution, were indispensable to his life, his thought, and even his mental survival. But the young abolitionist, contrary to the ways conservative intellectuals use him today, did not come to his natural rights solely from Jefferson's creeds or from the genius of the Constitution. Slavery taught him what it sought to destroy, a firm belief that his humanity, his essential rights, came from God or nature's God, from nature or from nature's God, even as humans could steal, brutalize, and destroy those rights by law when nothing stopped them. At the heart of Douglass's probing of his youth in his autobiographies was the idea that enslavement attempted to crush all semblance of natural rights in its victims. He saw that as its purpose. Douglass's eventual public appeals to the natural rights tradition, to the right of revolution, and his need to find a usable constitution to believe in should be considered in the light of his compelling tales, and there are dozens of them, of damaging as well as inspiring childhood memories. His embrace of natural rights began in his first speeches, and especially in his first autobiography, written at the age of 27. But it really began in his childhood daily confrontations with the violence and humiliation of slavery. Those first two autobiographies, the narrative in 1845 and My Bondage and My Freedom, which is his long-form masterpiece in 1855, are both testaments to the meaning of natural rights. In fact, they're one of the best ways to read them, in my view. Now, in the paper, I go through some pages of examples from the autobiographies, from speeches, from essays of him relating childhood experiences, teenage experiences, that he turns into analysis of natural rights. Now, of course, he's doing this in retrospect. This is the 27-year-old and the 37-year-old probing his childhood, probing his youth, and finding its uses. I have many such examples. In fact, he said they all began with my, quote, childhood reason. One of his favorites was to tell the story about his little white friends, 10-year-olds in the streets of Baltimore, the boys of Philpott Street, Fells Point. Oh, they were all Irish and German immigrant kids. And Douglass had this theory, his words, that little boys are all, quote, natural abolitionists until about the age of 11. They're good through 10, then they started learning their races, and they're not so good anymore. So, but until then, they were natural abolitionists. And so they were always asking him, Douglass, the autobiographer, who's always playing tricks on us. You learn never to trust somebody who writes 3 autobiographies and revises the third, the fourth time. But he said they were always asking him, Fred, why are you a slave? That made any sense. Douglass turns that in the autobiography into this beautiful statement about how freedom, the liberty these boys had, is something natural. But the slavery has the power and capacity to destroy what is natural, or it can. Again, I won't go into all of the uses, except one. I want to do this one in part because Chris picked up on it in his comments. Douglass was always using nature itself in his memories of his childhood to try to explain natural rights. Natural rights came from nature or God or both. And one of his favorites, I mean, there are many examples, but one of his favorites was to tell the story of the blackbirds on the Wye plantation. I don't know if any of you have ever been to the Eastern Shore. The Wye House is still there, the very same plantation house where he was a boy slave from really the age of 6 until 7, about a year and a half he lived there. He was transported back there a couple of times. These were the first deep impressions on his memory. And he tells the story of in the morning, and I've been there many times. Tells the story that in the morning he'd go out walking out of the old kitchen house where he slept, and there'd be these huge flocks of blackbirds, thousands of them in the giant trees behind the White House, and he would imagine himself on their wings, and especially when the flocks would all just take off and fly, and the noise they would make was to him the noise of freedom, the vision of freedom. He wished himself on their wings. I've stayed there a number of times. Now, the family of the Tomlins who own the place, Mr. Tomlins, the 5th generation descendant of Colonel Loeb, who owned it at Douglass's time. And they've let me stay there, and I get to stay in the old kitchen house, which is now a lovely 2-bedroom remodel apartment. But the old fireplace and the crawl space right next to it, where little Fred Bailey slept, is still there. It's the same fireplace, it's the same crawl space. That's the apartment I get to stay in. And one day I was there all by myself. I go out for a walk early in the morning. It was a spring morning, and there they were. 1,000 blackbirds in the tree. And they all took off. And it was one of those moments where you realize you didn't make up that metaphor. You saw that. And there are plenty of others. If you trace his footsteps on the Eastern Shore, you can see these are memories. I mean, he's obviously, as a writer, converting them into prose and into metaphor and into the trickery of good writing. But he learned that those blackbirds didn't lie. They were free. Somehow by nature. He wasn't. He used every event in his early career, whether it was confronting the issue of colonization or confronting the Fugitive Slave Act of 1850, which converted so many people who never really wanted to get near abolitionists into a kind of anti-slavery. Or Kansas-Nebraska Act, or the Dred Scott decision, and many others, into arguments, fierce arguments for natural rights, the law of nature. Now, natural rights, natural laws are much bandied about, much discussed, it's a distressed concept in so many ways. You start preaching about natural law, you lose people. But Douglass had nowhere else to turn. And it's interesting to me how many political theories, political philosophers, and some law school professors who have taken up Douglass now as a political thinker. There are many books now on Douglass as a political philosopher, political theorist. And all argue in one way or another, sometimes with different kinds of politics, that it's the natural rights tradition has sustained Douglass even to staying in America. Now, his transformation to anti-slavery constitutionalism is a historical story. And that's what I do in most of this case. I'm really just a regular old historian who tells things in the order they happen. So, a warning to the editors of the law review. But he transformed from that Garrisonian vision of this hopelessly pro-slavery constitution, so deeply complicit with slavery, there was no hope to be found in using American law to end slavery, into a full anti-slavery constitution. And he did it in about 3 years, 4 years. And he was happy to admit eventually that he had changed his mind, that he was inconsistent. He was happy to be inconsistent. These are very important years in his life. It's the age of 30 to 34. Think about that period in anybody's life. He's got 5 children at home by 1849. Wife Anna is trying to make a home. He's not making a living. They can't make ends meet. He's relying on gifts of, we like to think of Frederick Douglass as that textbook image, that virulent man, self-made virulent man who conquered all. That's nonsense. He had a complete nervous breakdown in 1851, was confined to bed, couldn't move his limbs, couldn't work, admitted it in his newspaper that he would not this month be writing because he was incapacitated, mentally incapacitated. He had help. Anna's running the house. He had made a new friend in Garrett Smith, a very rich abolitionist from Peterborough, New York, who was the funder. He was the Koch brothers of the left. He was the largest landowner in upstate New York. He had a lot of money. And he was a radical abolitionist. He was an eccentric dude. And he came out of some strange millennialist movements at first. He didn't always know where Garrett Smith was quite going, but he had money. And he would bankroll Douglass's newspaper mostly for about 3 or 4 years. His greatest help, though, came from a woman from Britain named Julia Griffiths. Julia was a brilliant, really well-educated English woman. He met in England in nearly 2-year tour there between 45 and 47. She came to the States, moved into the Douglass house, lived there for most of 6 years, moved out of the house after 3 years, after the Garrisonians accused him of having an affair with Julia in his own home under the nose of his wife and children, which we still don't completely know the facts about, but don't go there right now. But Julia was his editor, his chief fundraiser, his emotional companion, and among other things, she purchased the mortgage on his house so he could keep it, and she started his growing massive book collection for him. She was a great political advisor, kind of an ideological advisor. He comes under the influence, though, of a new circle of abolitionists, a new circle of writers, in fact. And one in particular I want to stress, because it's for the first time that I have now read him carefully, was William Goodell. Now, William Goodell is not a household word or name. He was a radical abolitionist who he was born in upstate New York. He grew up mostly in Connecticut and partly Rhode Island. He was a Garrisonian at the beginning of his career, a staunch immediatist, a deeply biblical abolitionist. He believed in what he called a Bible politics, believed in a kind of political theology. He parted eventually with the tribe of the Garrisonians because he was not an anarchist. He wanted to reshape the law. Goodell wrote a book that he published in 1843 that Douglass first reads in 1844, 45, and especially after he got back from England in 47. He starts reading these anti-slavery constitutionalists. He started reading Lysander Spooner, another very eccentric, radical kind of fringe abolitionist who also wrote an important book on the anti-slavery constitution. He starts reading Garrett Smith. Well, Garrett Smith never wrote a book. He wrote essays. And he had a lot of influence. In fact, Garrett Smith had a group of abolitionists he met with occasionally in upstate New York. Eventually were known as the Garrett Smith Circle. And it was that circle of abolitionists who formed originally the Liberty Party. I mean, the first legitimate anti-slavery third party in the United States, a political party. Garrison hated the Liberty Party. Garrison wanted none of his followers to ever get near it, none to be in the same city with those people. And Douglass not only started being in the same city, but he started reading William Goodell's Views of American Constitutional Law and its bearing upon American slavery. Goodell's book is not a great read. It's this kind of quirky, strange, a little bit disjointed 160-page text that takes you word by word, clause by clause through the Constitution and shows you how damn near every clause is anti-slavery. Now, we know every clause is not anti-slavery, but he chose to read it that way. And this hungry, young, 28, 29, 30-year-old Frederick Douglass, whose mind was always in transit, really, Douglass just wasn't meant to be an ideological member of any club, any tribe. Now, later on, he's a member of the Republican Party tribe, and he never leaves it. That's later on in life for a whole set of other reasons. But he was always looking for a new idea, a new strategy, a new method, a new way. Again, he's this person without any formal education. Have you ever known somebody who had, frankly, no formal education, and yet seems to be getting on in the world? They do things that are effective. They're probably people who have learned how to learn from you, and you, and you, and you, and you. And a new idea here, and a new idea there. Sometimes they find that one idea and they stay that way the rest of their lives. But not most. He found in Goodell's book a new text. Not a new Bible, but a new text, all about natural rights. In fact, Goodell took kind of a natural rights microscope to the Constitution. And to the young Douglass reading this, I don't have any letters where he says, "Oh my God, I read William Goodell today, it changed my life." But we do have him saying, in 1863, in the midst of the Civil War, in a speech, no one ought to be given credit for the destruction of slavery more than William Goodell. I'm not on a crusade to make William Goodell a household. There's no decent biography of him. He's a strange duck, but a fascinating radical, but also a political radical. What Douglass found in Goodell was an anti-slavery politics and an anti-slavery constitution. In the paper, I have numerous examples what Goodell does, even with the 3/5 clause. This is where the anti-slavery constitutionalists can kind of drive you crazy, because they will say over and over, "We're slaves, not there. Aren't you?" Period. Goodell ends up saying it's just a tax bill. It says the Yankees got the worst of it. Well, yeah, we could take that one apart, but that's where Goodell begins. He says it's not. He says it's about human beings, quote, in distinction from things. The infamous 3/5 clause provision, he said, was, quote, only a tax document, meaning it was also for deciding taxes and representation. For the 10th Amendment, the so-called reserved rights or powers of the states, Goodell broke down every word of the text. And by the way, in his book, he does it with Webster's dictionary in hand, constantly. This is what these guys did. He says, and now and he does it with wit. The book is funny at times, even if you disagree with it. He says, and now I bring Noah Webster to the stand. Over and over. He says, what powers in the 10th Amendment? to reduce immortal souls to chattels, to transform lawlessness into law, to construct a rectangular triangle. Goodell's analysis was above all an unyielding application of natural rights doctrines and drew Douglass into its sway. The reserved rights of the states, wrote Goodell, cannot include reserved wrongs. In language ripe from radical abolition's rhetorical well, he urged that the 10th Amendment be used as a dagger in the heart of states' rights doctrine rather than its buttress. Douglass loved that, as Douglass already was showing how much he hated states' rights. He will have many other reasons to hate states' rights in the years to come. Then Goodell, like all the anti-slavery constitutionalists, went to the preamble and identified the 6 objectives, preamble of the Constitution. Anti-slavery constitutionalists love this, and they made the most of it. They named the 6 objectives of the preamble of the Constitution. How many Americans ever, if they even read the preamble of the Constitution, actually stop on blessings of liberty, the common defense, the 6 basic objectives of the preamble? Goodell breaks them all down in detail and says every one of them is anti-slavery. Douglass would basically lift Goodell's language about the preamble and use it himself in many, many speeches down the road in the 1850s. 2 of Goodell's most lengthy analyses were the anti-slavery constitutional provisions were Article 4, Section 4, that the United States shall guarantee to every state in the Union a republican form of government. And then the other was, of course, the due process clause of the 5th Amendment. These in some ways were the 2 favorites of the anti-slavery constitution, that republican form of government. Now, again, we can get bored or tired of their use of that, but Goodell breaks down the word republican from dictionaries in great detail and concludes eventually that no slave state is or can be a republic, because it denies human liberty, human rights, and representation and consent to such large parts of its population. He also trots out James Madison, which anti-slavery constitutions always did. Madison's famous passage about believing that property in man is not possible or not right, or Madison's language about how the Constitution cannot favor a favored class. Oh, Goodell loved that one. Made most of it. The moral reasoning in this, if that's what we want to call it, is simply that oligarchies can never be republics. Therefore, the United States Constitution is anti-slavery because it guarantees a republican form of government, and it is not doing that in every slave state. Douglass, after reading Goodell and Spooner and a few other people, but especially Goodell, is stepping on board. Slowly at first. He doesn't make this transformation. There's no road to Damascus moment. It's a process of about 3 to 4 years. Now, that process is best found in the letters he exchanges with these people, especially with Garrett Smith. There are many of them, I won't cite, but maybe one of them or 2. Garrett Smith becomes the person he has to write to not only to get money to support his newspaper and pay his mortgage, but he becomes this mentor who keeps asking, he keeps saying, you know, I'm not quite on board yet. There's still parts of the Constitution that are obviously pro-slavery. What are we going to do about that, Garrett? Smith just keeps writing back to him and saying, you'll get it. You'll come along. You're getting there. Oh, and by the way, the Liberty Party is meeting in Rochester next week. But what Douglass has now changed his attention to, no longer moral suasion by itself and just converting the hearts, no longer his famous slaveholder's sermon where he was always, and he loved doing that speech. That was the attack on religious hypocrisy about slavery. He turned his attention now to the problem of federal authority at the base of slavery's stranglehold on America. It became now his principal subject, and not just in speeches, but in editorials. Now, moral suasion, he never gave up entirely on moral suasion. Who does? We all still want to convert somebody's heart if we can, politically or otherwise, even though if you're like me, you have cousins who voted for Trump twice. You know, Trump. Anyway, but moral suasion still worked on Sundays, but he had to write 4 editorials by Thursday and Friday for his newspaper. And that's not what he wrote about in his editorials. He wrote about politics. He wrote about law. He wrote about events. He wrote about constitutional principle and constitutional practice. He writes to Garrett Smith in April of 1850, still a little perplexed about some parts of the Constitution. I'm not fully on board yet, but he says, quote, liberty and slavery, opposite as heaven and hell, are both in the Constitution. And then he says, this is precisely the radical defect. It offered no resolution for the, quote, war of elements, which is now rocking the land. Douglass gave his sympathies, he said, his word, at this juncture, 1850, to the anti-slavery Constitution, but not yet fully his judgment. Not yet. I give you my sympathies, but not quite my judgment. Barry Smith writes back. He concluded for the moment, he said, in that letter, that the Constitution was, quote, at war with itself. 2 constitutions, indeed. He now had to decide if he's going to stay in this business of radical anti-slavery, which side he was on. And there were 2 constitutions at war. And I don't think I fully understood that until I read James Oates's recent book, but that's another matter. By January 1851, we still find Douglass teetering between legal and moral logic. He's not quite there yet, but he's close. He had about decided, he writes to Garrett Smith, to let slaveholders, his words, and their northern abettors have the laboring oar in putting a pro-slavery interpretation on the Constitution. Beginning now to swallow the theory whole, he proclaimed, quote, I am sick and tired of arguing on the slaveholders' side of this question. It's a pretty practical statement, although they are doubtless right about the intentions of the framers of the Constitution. He stumbled over whether, quote, it is good morality to take advantage of a legal flaw and put a meaning upon a legal instrument the very opposite of what we have good reason to believe was the intention of the men who framed it. Although he didn't quite completely trust it, Douglass needed the detailed textual analysis of Goodell in these difficult days, buffeted by violent rescues of fugitive slaves, by a national political system tearing itself apart, by all kinds of events that were shocking and essentially unprecedented. Garrett Smith's arbitrary, vague declarations that slavery was such a moral outrage that it simply could not garner legal status was not enough for the protege. Douglass did tell his mentor, though, that he had, quote, ceased to affirm the pro-slavery character of the Constitution. He had argued his way, read his way to this new position, rather than merely imbibing it. He didn't do this because somebody told him to. Soon Douglass made his new argument feature of the greatest speech of his life. That's the 4th of July speech of 1852. If you read the 4th of July speech, which many people do now publicly, 4th of July, it's the most read words by Douglass ever, possibly more even than the narrative. You'll find embedded in it about a 2-page section on the anti-slavery Constitution, which he sort of plucks in. Gives it a cameo of sort. But he also gave some language that people now on all sides of our own political spectrum use. In that instrument, he said, the Constitution. I hold that there is neither warrant, license, nor sanction of the hateful thing, slavery. But interpreted as it ought to be interpreted, the Constitution is a glorious liberty document. American conservatives love that phrase. There's a brand new book out by a journalist named Damon Root, conservative journalist. I'm not, that label is his own label. I'm not casting aspersions on anybody here. In this book by Root, Damon Root, he actually does an effective reconstruction of Douglass's anti-slavery constitutionalism. And only at the end of the book does he have kind of the necessary stabs that Douglass, that conservatives need to do. He says, nevertheless, in spite of all this brilliance on the Constitution and his change in the Constitution, his realization of how anti-slavery the Constitution was, Douglass never gave up on his firm belief in individualism and his staunch distaste for collectivism, which are two terms that don't even make much sense, frankly, dealing with Douglass, in my view. But nevertheless, the right in America loves their Douglass, some with research and some with a narrow ideological set of assertions and a need to enlist him in their causes of self-reliance, limited government, sometimes merely because he was once a Republican. With different aims, both left and right can get right with Douglass, at least on this ultimate adoption of an anti-slavery constitution. And when he called the Constitution a glorious liberty document, some analysis, everybody had what they wanted. All ends of the spectrum used it. Now, I want to get on to the end of this. It's a much longer paper, as you can tell. In the 1850s, Douglass, like so many people, it's easy to forget what a horribly volatile, that's a nice word for it, turbulent, destructive time the 1850s was. I just got asked recently to write an essay, a long essay, a 10,000 word essay for the New York Times Magazine, only to learn they edit essays about 11 times before they publish them. So it's still in another editing. But it's all about how the 1850s might be a template for understanding what we're going through. I hang the piece on the Dred Scott case. But it's also about how polarized the 1850s were. I mean, that's such a nice word, polarized. We need a new term, actually, I think. Douglass, depending on which year it was, he would support the Republicans in 56 and sort of in 1860, but in between he would support this far-out party that William Goodell founded, called Radical Abolition Party, which got a few votes in upstate New York, a couple of votes in Pennsylvania, and a few out in Ohio, and elected one person to Congress, Garrison. And Douglass would join them in the off-year elections, and then go back to the Republican. He didn't know where to turn. He was looking for a home. He was looking for a pragmatic home, and he was looking for a radical home. And the two didn't know it. We're not always in the same organization. So, with Dred Scott, like everyone else, Douglass's response to Dred Scott shows us what terrible the 1850s were becoming. I mean, Dred Scott has always, in my teaching, always been the moment I refer to as almost the point of no return. I mean, I hate this old argument about when was the Civil War inevitable. It's not the war that was inevitable now, but something like disunion probably was after Dred Scott. He gave an extraordinary speech after Dred Scott, speech he worked very hard on. In May of 1857, a couple of months after the decision. And He rewrote the preamble. He said, quote, "We the people, not we the white people," of the preamble. Not we the citizens or the legal voters, not we the privileged class, and excluding all other classes, but we the people. Not we the horses and the cattle, but we the people, the men and the women and the human inhabitants of the United States do ordain and establish this Constitution. That's his way of saying to Roger Taney, you say we have no rights. What part of we the people? Horses have no rights. We do. Now, that speech, in its ending especially, reads a little bit like whistling in the graveyard. It's a despairing speech. It has that famous, from Matthew, that famous biblical passage. I walk by faith, not by sight. A passage Douglass would use in many different situations. Now, at the end of the 50s, in fact, in spring 1860, Douglass gave his most robust speech, his most robust telling of the anti-slavery Constitution. He gave it in Glasgow in Scotland, March 26, 1860. The speech is called The American Constitution and the Slave. It's a speech, I think, taught in some law schools. It's the place most, if people want a single visitation on Frederick Douglass and anti-slavery constitutionalism, they tend to go to this speech because it is a fulsome sort of rehearsal of the anti-slavery Constitution. He gives it in response to a George Thompson, the most famous and important British Garrisonian, and still a Garrisonian, who has just recently lectured in Glasgow and attacked Frederick Douglass. Douglass is in England and Scotland because he has fled the United States after the John Brown raid. He's fled for his life, not knowing that he can never go back to America. He's lonely. He's some despair on and off. He doesn't know if he'll ever see his 5 children again. In fact, he will only return the next spring at the news that his daughter Annie had died, diphtheria epidemic at age 11. But it's in this speech that Douglass declares himself a textualist. What is the Constitution? He says. Go to the text. Doing what everyone else does. Go to the text, he says. It is no vague, indefinite, floating, unsubstantial something called to any man's fancy, now a weasel and now a whale. It's made up of words. It was, quote, a plainly written document, he says, to be interpreted in its words. The mere text, Douglass's words, the text and only the text, and not any commentaries, is the Constitution of the United States. And then he goes into intentions, and he brings the word intentions down on his audience over and over. He says, there was no secret intentions by the framers. They weren't secrets. They did what they said they were going to do. But they said more than the pro-slavery stuff. Douglass admitted that there was still to him a chasm between the text and the practice. That, quote, the American people have made void their law by their traditions, or by their practice. The Glasgow speech was both belief and strategy, as much political argument as it was legal. Douglass thoroughly embraced the idea that the 1808 restriction of the foreign slave trade had been anti-slavery from its inception. Of course, that's debatable. Both sides, both anti and pro-slavery constitutionalists use that one, of course. And for the slave insurrection clause, Douglass insisted in the Glasgow speech that, quote, there is no such clause. Slavery is itself the insurrection. He's really become Goodell now. Nothing to worry about in that, given the federal government's power to counteract slave insurrections or any other kind of insurrection. Slavery is the insurrection. Use the document to destroy the real insurrection. And toward the end of this speech, it feels a little bit like whistling in a graveyard too. And you can sense the dire fear. This is spring 1860. This is the eve of the 1860 election in America. And he's a lonely exile in England. He's had to flee because he's going to get hanged if he's caught, because he was complicit with John Brown. He says, quote, "There must be something more than history, something more than tradition, to lead me to believe that law is intended to uphold and maintain wrong." Well, that's a kind of a pleading. But when I read that passage just recently, I thought that must be the way people feel protesting outside the Supreme Court today. Must be something more than tradition. Must be something more than history that make this court do that, in their view. Okay, there's much more to say about the famous Glasgow speech. I think Chris might. The two constitutions were now at war, soon in real war. One would have to win. Now, I just want to end with a couple of thoughts on this idea of two constitutions then and now, and even the third constitution, and maybe lots of constitutions, depending on how we read them. Historians can and do change their minds, as well as about interpretations, about the evidence we use. We don't like to admit it. We like to take positions, and argue them, and hold them, and fight about it. In fact, I've referred to Jim Oates here, who's educated here. No one loves the historiographical rumble as much as Jim Oates. But he has recently said in his new book, Crooked Path to Freedom, that, quote, "Once upon a time," he said, he believed that the proponents of a pro-slavery constitution had the better of the argument. And of course, the Constitution is implicit in slavery. And all that anti-slavery constitutionalism was just strategy, just political wish fulfillment. But now he says in this new book, and he's been saying in other books, no, there was an anti-slavery constitution. They found it. There were two constitutions. He says both of them, both sides in this ultimate American struggle, ultimate American issue, colonized the Constitution. And I was moving this way before I read Jim Oates, but Jim kind of did it for me. I too changed. Through my years of teaching, I've always said, in fact, in my first book, which was 1989, if I admit it, on Douglass, I argued that Douglass's anti-slavery constitutionalism, quote, was, quote, dubious, just strategic, wish fulfillment. So I looked back at it and I thought, ooh, dear, there I was. And in my recent biography, I changed the two quite a bit. I try to point out in time, through change in time, how he argued his way, read his way by what he called careful study, those are his words, to a new legal and moral logic or a anti-slavery constitutionalism. We still have at least two constitutions on many issues, if you think about it. The nature of federalism, abortion rights, voting rights, environmental protection, the place of redistributive justice in American society. So many of these are before the court right now. Election laws, gun culture, the right to bear firearms, how to teach about race and slavery and gender in classroom, whether state legislatures should have sole power over election law and procedures, God forbid, whether the federal government should regulate a national, global, post-industrial economy that has made hyper-economic inequality a permanent part of our polity, and many, many more. Our democracy that we talk about, it seems, every day now, about which we are justifiably worried, is in some ways no democracy at all, as long as we limp along under the quite undemocratic institutions of the US Senate and the Electoral College. Our system of selecting and confirming Supreme Court justices is broken. We have a majority on the Supreme Court determined to return every power possible to the states, reverting the Union, that's in the preamble, to generations ago when it was a collection of battling legal sovereigns with common borders. A historical template for these issues may always be that unfinished failures and triumphs of anti-slavery constitutionalism struggle against pro-slavery constitutionalism in the 1850s and 1860s. Or maybe it's the Reconstruction Constitution versus the Redeemers counter-revolution. Or the Civil Rights Constitution of 1965 versus those now rolling it back in the name of misbegotten originalism. The problem we have, whichever constitution we draw upon, whichever side of this we fall back on, we now, though, live in a culture where we're trying to do what Douglass said he and his generation were still trying to do in the last speech of his life. His great speech on lynching, or Lessons of the Hour. He said, the problem with the lynching issue is you have to take the power out of the lie. The lie at the root of lynching, that every lynching is caused by sexual assault by a black man on a white woman. Taking the power out of lie. We want law to be the way to settle all this. Well, I will end. There's much more here. I will end though. I take you 10 years ahead from Reconstruction to the pivotal, terribly important 1883 civil rights case, U.S. v. Stanley, which was brought out of Douglass. Another fire-spitting, barn-burning speech about anti-slavery constitution brought him back rehearsing every element of the anti-slavery constitution all over again in a moment that was bleak, a moment of defeat, really complete defeat. 14th Amendment's being crushed. The Civil Rights Act of 1875 declared, in fact, null and void. And he, in fact, said in that speech, intention? You want intention? Whose intention? When? For what purpose? What's left of intention when you do this? As they did, the court did, in the U.S. v. Stanley case. In that speech, he ends by trying to, like he always did, whether it was the Dred Scott speech, the many speeches in moments of difficulty and despair. In fact, it reminds me of the morning after Trump's election, or whatever that was, November 9th, 2016, whatever the day was. I had been scheduled to give a lecture at the Harvard Law School. That's the first time I ever spoke at the law school. I was terrified. And I had promised some elaborate talk on Douglass and the Constitution or something. And I got on the train that day and I said, I can't do this. If anybody shows up, they don't want to hear about that. So I just went to 3 great crises in Douglass's life. I brought a couple of books along with me. And I tried to find, what did he say in this moment of total despair? What did he say in this moment of total despair? What did he say in that moment of total despair? It's Dred Scott, 1883, U.S. v. Stanley, and then forgetting what the third one. And somehow it worked. Only because I think people just wanted to be somewhere and listen to something, and nobody was smiling. But on October 3, just last month, in oral arguments in the Supreme Court over Alabama's challenge to Section 2 of the Voting Rights Act of '65, Justice Ketanji Brown Jackson firmly responded to the Alabama Solicitor General, Edmund McClure, who claimed that the issue of voting rights was and always had been race neutral. Carefully, Justice Jackson schooled the court on the historical inaccuracy of such a claim. She said the framers of the 14th Amendment never meant it to be race blind. Bad history is bad history, she was saying in so many words, and potentially dangerous. A quick look at the Congressional Globe and speeches by the amendment's principal author, John Bingham, would surely prove that, and Brown Jackson cited Bingham in her remarks. Justice Jackson kept it clear and simple, as though asking her colleagues to go read their history of Reconstruction. She can hope. The entire point of the amendment, she said, was to secure the rights of the freed former slaves, to make freedom real for, quote, Black citizens. It would appear that Justice Jackson and Frederick Douglass are having a conversation, even if a lonely one, across time. Just now, to make this country have the same conversation is as harrowing as Douglass's dark plea in 1883. At the end of that speech on the Supreme Court's decision in the civil rights cases, Douglass took up the fear, the moral panic among whites about what was always called social equality in overthrowing the 75 Civil Rights Act, alleged to be the point of that bill they were striking down. He appealed to his lifelong creed about natural rights. It had been a bill, he said, if it had been a bill, he said, for social equality, so is the Declaration of Independence, so is the Sermon on the Mount, so is the Golden Rule, so is the apostolic teaching that of one blood God hath made all nations to dwell on the face of the earth, and so is the United States Constitution. Thank you. How do I write long papers you have to cut? Short paper, okay.
That's what I've done, written short paper that I have to add.
Oh, that's interesting.
Thank you for inviting me to participate in this symposium, and I'd like to thank David for this provocative paper. It's fascinating to me to learn that he has come over to the position of my friends, Jim Oakes and Sean Willets, on the concept of the anti-slavery Constitution. I'm now faced with these three very powerful advocates of the concept. I might be moved in that direction, but not yet. First, I'm reminded when I read this paper of what an extraordinary person Frederick Douglass was. The story of coming from where he began to where he ended and all the things that happened to him show him to be an exceptional individual. At the same time, as he suggested himself, we're discussing the importance of having formal education. It's clear how much talent was lost over the years through the system of slavery and a doctrine of white supremacy that blighted the lives of many people of African descent and prevented them from reaching their fullest potential. Douglass was indeed a singular figure, but he was singular by design, by the design of a system that tried to keep people like him down. They didn't succeed in his case, but I'm reading it and thinking about his extraordinary nature, but I'm thinking about other people who might have been as great as he or even near as great as he, never had a chance to do that. I especially love the idea of Douglass learning about natural rights philosophy through his time in slavery, which fits very nicely, I think, with the fact that former enslaved people and their descendants have been the biggest proponents of American idealism throughout history. The people who had been deprived of liberty knew its true value and wanted to uphold the values of the American Declaration of Independence and its idea, its statement about the natural equality of mankind. Hannah Spahn, a Jefferson scholar, has written a work that will soon be published that talks about the fact that Black people in the 19th century were really the ones who helped fashion and create the Declaration as America's creed, because they depended upon it. And that in their pulpits and writings and so forth pushed this notion of the Declaration as an American ideal that had to be lived up to. While I'm sure there must have been other people of African descent who joined Douglass in his move to seeing the Constitution as a liberating document, for the most part, has been the Declaration that has foisted the imagination, has sort of ignited the imagination of African people, African American people, and put this forth as the ideal of a document that liberates people, American founding document that has the greatest potential for doing this. My own position has been more in line on this notion of the Constitution and its anti-slavery aspect or not, with what David's original stance. Perhaps I will migrate. Again, I'm not so sure. Which basically, because basically I think the central problem with the idea of the text of the original Constitution providing an anti-slavery message, or is predominantly anti-slavery, is that the language itself promotes slavery, protects slavery. The 3/5 clause is mentioned, and even more directly and importantly, the fugitive slave clause. The ban, holding up on the ban of importation of enslaved people, slaves, did take on what had been a proto-abolitionist dream notion, the idea that ending the slave trade would result in the eventual demise of slavery. So it is abolitionist in that notion. But by then, it should have been clear that the opening of Louisiana Territory to settlers, to white settlers and southern white settlers who would leave and move to the West with their enslaved people, would result in the expansion of slavery. The fact that they weren't bringing enslaved people in would not end up doing away with slavery, causing its demise. So those are the problems. The problems that I see at the beginning are just the textual problem. If you look at those things as part of the story, you understand that there was an understanding that slavery was going to be protected. Neither the Constitution nor the Fugitive Slave Clause mentions the word slave, or property, I should say. It doesn't mention slave, but it also doesn't specifically talk about people as property. But there had to be some idea of an interest in the person for the Fugitive Slave Clause to work. What was the basis of recapture? You think about, I remember talking to Jim about this Harvard Club. What's the basis of it? And well, marriage, what a husband could bring a wife back, but there was a marriage contract. That gave the right to have an interest in a person. Children, we always assume that people have a right to their children. What basis could there be other than thinking that enslaved people could be a form of property that would allow them to be recaptured? So the thinking is there, even if the words aren't used, they are very, very powerful. There was some reticence, obviously, about using the word slave. Now, the fact that they felt a little embarrassed about that doesn't mean that they were necessarily anti-slavery. When I was working on another book on the Hemingses of Monticello, I was talking about the French attitude about slavery. And the French Parliament, which is not Parliament in the sense that we typically think of it as a legislative body, it was in the 18th century, it was more of a judicial body. They had the task of registering laws. And they absolutely refused to register a law that had the word esclave. They didn't want to, but even though they're passing legislation directing how slaves will be handled, how slavery would proceed, they didn't want to use that word. So the reticence about using the word and being frank about what you're doing doesn't, to my mind, equate with, add up to being anti-slavery necessarily, because we see this in other places. The French obviously with Saint-Domingue and Guadeloupe and Martinique were full into slavery. They just didn't want to use the term. The idea that Douglass, because Douglass became, he said, they would use his quote, sick and tired of arguing on the slaveholder's side, doesn't change the fact that the document actually created a federal union of states that each had their own cultures, each had their own laws, and each had their own understanding about how they would proceed together in the union. The document allowed for some of the slave states, the states that had slavery, all of them colonies had slavery. It allowed some of them to have gradual emancipation statutes and free enslaved people, even as it allowed others to stick with the system they had before. That was the understanding they had. This notion of a nation, they weren't a nation yet. They were a group of people who had come together. It would take time to get to the point that they would think of themselves as a nation. We've done it yet. Actually, we still seem to be arguing about that. But at the time, the creation of the federal union, there was a notion that each one of them would have the capacity to make their own way. And one of the ways that it was agreed upon that they would be able to make their own way is to allow the states who wanted to maintain slavery to do so. So I think Jim Oakes and David's earlier position that the Constitution was essentially pro-slavery is more correct. It did not mandate that any state had enslaved people, but it also allowed the ones who wanted to do it to do so. And that, to some degree, is an acquiescence in the institution that supports the idea, Garrison's idea, that it was a pro-slavery document. The fact that there were people who were deeply committed to using the Constitution to argue against slavery doesn't really answer the question. I mean, lawyers do this all the time. There are documents that one side will say this, the other side will say that, and very often the language can be pretty clear about what the answer is. The fact that you want it to be that doesn't necessarily make it that. And the context, as I said before, was a union of states with very different beliefs and very different economic systems, and acquiescing in the sort of compromises that were made were done to make sure that the union would actually be successful, that it would actually exist to begin with, because it wouldn't have. There's no doubt that Southern states would have not gone into the union if they didn't think that the document promoted or allowed for them to have their way of life, as they eventually came to call it. This is in no way to dismiss Douglass as a deeply committed political figure. I think he was engaging what David said he was when his first mind. The proponents of the anti-slavery Constitution were looking to find a way to use law to make their arguments, to help a pragmatic way to bring their views into fruition, to change the United States. Thomas Paine and Tocqueville very famously noted the importance of law to Americans. Law-minded people would naturally think of looking to the law as a way of bringing about the kind of change they wanted to see. So it was natural, I would think, for Douglass, who considered himself to be an American, and who wanted other African American people to be true Americans, to come to the view that the supreme law of the land supported the emancipation of his people, because that's what Americans do. We argue on the basis of law. Tocqueville said everything eventually ends up in the United States in court. People argue on the basis of law, whether they're on sort of their day-to-day activities. So it doesn't surprise me that he would come around to this position. The person who wants to be an American, to use this most American of vehicles for instituting change. And of course, this is something that a tradition that African Americans have continued. This is what comes through very clearly in the paper to me, as I kept thinking about how Douglass is very much like other African Americans, and whether he started the trend or not, or his experiences in slavery that are the experiences of other people, ancestors and so forth. He's very familiar in the sense. And so I'm not surprised by his change, his understanding of what he had to do in order to change the society in the way that he wished to have it go. Now, of course, he wanted to use the Constitution, or to say that the Constitution pointed towards emancipation and that it could be a liberating document, but in the end it wasn't. It didn't solve the problem. War solved the problem. And historians don't like to talk about inevitability, but it's hard to think of the institution of slavery as it existed in the United States ending any other way than the way it ended. It certainly would have been a constitutional change as a reason. When the dust settled after all of this, there were amendments to the Constitution to do the kinds of things that Douglass and others suggested were already provided for in the Constitution. The 13th and 14th and 15th Amendment transformed the Constitution, the old Constitution, and made something new. This brings me to a question, I'm racing through this brings me to the question, why does it matter to us whether the Constitution was pro-slavery, the Constitution, the Philadelphia Constitution was pro-slavery or not? David seems to suggest that it does, that it has something to do possibly with our future. The answer to this question has something to do with our future. Why is it that the Constitution created after the Civil War that focuses on ending slavery, bringing Black people into citizenship, and giving everybody the equal right to vote? Amendments, in the 14th Amendment in particular, that transformed American society and made modern America, not just in terms of race, corporations, all kinds of things. Why isn't that the Constitution that really matters, and not the Constitution with arguing about whether or not Madison and the cohort and the people who gathered at Philadelphia intended to create something, intended to create a pro-slavery constitution or an anti-slavery constitution? We have a version of the Constitution, you mentioned before, that even we have a version of the Constitution that was remade in the 20th century. Those kinds of things strike me as a better, they're good for historical purposes, but I'm not, the bridge between the history and the present day problem solving is not clear to me. I like to argue about anything. Was it pro-slavery, anti-slavery, whatever, but I'm not quite sure how that's going to help us right now answering that particular question. I have a colleague, we have a parade of legal historians who, I was the chair of the entry-level hiring, and there are lots of these wonderful PhD people, JD PhDs, and they write so well, so they always rise to the top. I have a couple of colleagues who are a little skeptical of why do we need more legal historians? And one said to me, said at one point, well, why is it that we have to go back? Why do we need history to answer a question? If we have a problem to be solved today, why do we have to go back to the very beginning of time or whatever to figure out what we're supposed to do about it. Can't we do it without it? Now, I wouldn't adopt that position, but I would suggest that post-Civil War Constitution, 20th century Constitution created by the Civil Rights Act, the goals of the Civil Rights Movement should occupy us. Those are the things that have the potential for helping us go forward. I'm not sure that arguing about the Federalist Papers and those kinds of things, as much as law professors try to do that, are going to help us. I think Douglass, I mean, we should have, I think of Douglass, who, in my mind, can lay claim to being perhaps the greatest American, is a founder. John Bingham is a founder. The radical Republicans who were trying to bring Black people into citizenship, they can be founders as well, and people don't, they know that Douglass. But these other people, we don't know, we don't talk about, we don't revere. And it could be that we focus on Philadelphia, because we know that members of the public fetishize the founders of the founding generation, and is the wisdom that they imparted, we must draw upon that before we go forward. My hope is that we can move beyond that, not move away from it. Far be it from me. I write about Jefferson. You know, I'm not saying don't forget to pay my attention to the 18th century guys in wigs. I write about them, but I'm saying we have to bring new founders, argue about other things than what the original Constitution was going to be, because I think this is what we're supposed to be, because I think that this offers the best opportunity for us to move forward. Thank you.
Oh, goodness. David, for his extraordinary knowledge, his, when they say so, his passion for learning from that knowledge and or teaching from that knowledge. Annette, for her incredible tough-mindedness, and a kind of pragmatic sensibility, if I may say so. For me, well, David said he read my paper, which I sent to him in a moment of foolishness, and that it was scary. Well, you know, when I write a commentary, things creep into it that I'm thinking about. And sometimes the things that I'm thinking about at the moment of writing a commentary have nothing to do with the subject of the commentary as such, but it becomes something of a challenge to see whether there is a relationship. So there may be something a little scary about what is to come. I ask your indulgence. I hope it won't go on for too long. And there is a reception afterwards, so you can recover over beer and wine. As David's presentation stresses, just as his biography, Prophet of Freedom, stresses, in a century notable for oratory, Frederick Douglass's capacities as an orator were astonishing. He was a master of words, he was a master of many words. Language was central in his life. Eventually, I will ask, what does it mean to be immersed in language? This is a question of relevance for all of us because we are all immersed in language. And I will arrive at that question eventually, but I'm going to start out just by thinking about words. So whenever I think of Frederick Douglass, I always find myself thinking of one particular word. Word he seems to have used on only one public occasion, but I think with deadly effect, the effect of a true orator. And that word is scrivener. Scrivener. Scrivener means, of course, one who is authorized to draw up or certify contracts, deeds, other legal documents. It means a notary, a clerk. Melville's Bartleby was a scrivener, as we all, I think, will be aware. He was a clerk employed to copy documents. In that extraordinary story, Bartleby was one of a host of copyists and clerks who haunted Wall Street law offices and brokerage firms in the 1850s, the moment the story is set. They were the literate poor, moving restlessly from place to place looking for employment. They inhabited what Michael Rogan called the claustrophobic gloom that pervades Melville's novels of mid-century racial capitalism. The lawyer, who is the narrator of the story of Bartleby, he describes Bartleby, interestingly enough, as one of those beings of whom nothing is ascertainable except from the original sources, and in his case, those were very small. Bartleby is an anonymous personage. He is of no apparent social significance whatsoever. By the end of the story, Bartleby has become almost literally a non-entity. So why do I wish to associate Douglass with this word? The word scrivener appears in what David's paper refers very properly to as Douglass's most famous expression of the anti-slavery Constitution, that speech of March 26, 1860, delivered before an audience in the Queen's Assembly Rooms and Concert Hall at number 1 LaBelle Street in Glasgow. So what does Douglass say there that I think is of such significance? And with your permission, I will quote a bit of length. You will have heard some of these words from David's paper already. He says, the paper itself, and only the paper itself, with its own plainly written purposes, is Constitution. It must stand or fall, flourish or fade on its own individual and self-declared character and objects. Where would be the advantage of a written Constitution if instead of seeking its meaning in its words, we had to seek them in the secret intentions of individuals who may have had something to do with writing the paper? What will the people of America 100 years hence care about the intentions of the scriveners who wrote the Constitution? These men are already gone from us, and in the course of nature were expected to go from us. They were for a generation. The Constitution is for ages. Now, admittedly, I may have a subjective and prejudicial reading of or ear for what those words imply to me, but in my ear, the word scrivener intentionally drips with contempt. Deified founding fathers here become merely copyists. And of Frederick Douglass, well, as David has told us, he becomes a textualist. Now that source on which I rely for my keyword is only one of several versions of the March 26th speech of existence. John Blassingame's multi-volume collection of the Frederick Douglass papers actually reports there are 7 distinct sources for the speech. He chooses one published somewhat later, which is in a tract which combines Douglass's speech with the speech given by I forgot his name. The English Garrisonian who has been kind of following Douglass around in Glasgow, contesting his anti-slavery constitutionalism. Three of their sources are Glasgow newspapers, one of which I've been able to trace, and it, in fact, confirms the source that I've used. Fourth source is an undated pamphlet. The fifth source on which I rely is, in fact, probably that undated pamphlet. It is in the second volume of the Life and Writings of Frederick Douglass, which were compiled and edited by Philip Foreigner, published in 1950. Foreigner was the first person to collect Douglass's writings. The existence of at least two versions of the text naturally leads one to ask why I prefer Foreigner's text, and the reason is simple. Douglass was an orator. Foreigner's version reeks of oratory, of spoken word. The newspaper report I located seems to confirm that that particular word was spoken. So I have some confidence that Scrivener was indeed delivered with all of the sarcasm and the contempt that I attribute to it. Now, all of this does no more than illustrate that historians obsess about their sources. So to cut to the chase, why do I think the word is so significant? Now, the founders were, by and large, either proponents of slavery or reconciled to the inevitability of the continued existence of slavery, and the document they produced nevertheless sustains readings that are anti-slavery. And there is nothing, in my mind, remarkable about that. There is no text that can be controlled by its author. No matter what the occasional Supreme Court justice or historian for that matter may think. As Blight has told us in his post-1848, post-Garrisonian phase, Frederick Douglass, who had previously thought the Constitution pro-slavery, became a first proponent of the possibility that the document could sustain an anti-slavery reading. Unlike others who embraced the Constitution as anti-slavery, such as, for example, Salmon P. Chase, Douglass founded the possibility of an anti-slavery Constitution not on any attributed anti-slavery intent to be found amongst the founders, to whose intent, it seems to me, he professed indifference. He found the possibility on a reading of the text. He reads a text. He does not seek to divine authorial intentionality that supposedly lurks beneath the surface of texts and dictates their meanings. The Constitution declares itself, he says, in words on paper, and those are the only words that matter. Now, the unfortunate answer to Douglass's question, whether the people would care about the intentions of the Scriveners, the unfortunate answer to that question, as we all know, is that whether or not the people care, legal elites of all political stripes, of all professions, whether juridical or forensic or academic, they care a lot, to the point that the Constitution is firmly in hoc to the endless musings of those legal elites about its Scriveners' intentions. American legal and constitutional historians have played a role in that state of affairs. One of the signal achievements of the constitutional history of the last decade, it seems to me, Walt Stryker in 2009, George Van Cleve, 2010, they had established, at least to my satisfaction, that the Founders' Constitution was written quite intentionally to accommodate slavery. That very achievement tends to push to the margin, however, attempts like Douglass's to read it without privileging historical intentionality. And though legal historians in their time have abashed originalism by demonstrating that legal meanings change as their contexts change. That very contextualizing method, historicism, as it is called, nevertheless binds the meaning of a text synchronically to the context in which it is to be found, to the moment and circumstances of its origin or of its subsequent reinterpretation, such that the text is always located somewhere. It's somewhere in mechanical historical time. It's like a butterfly stuck on a pin. Historicism privileges context over text, so that meaning is rendered merely a creature of moment. Historicists, for example, would have little time for Douglass's fondness for natural law, principally because natural law, of course, is not, in our sense of natural law, is not to be located in fixed moments of time. As a practical matter, Douglass knew perfectly well, it seems to me, that the original intent and meaning of the Constitution makes it a pro-slavery document. He wrote those exact words early in 1849 as he was shifting toward his anti-slavery textualism. So we could conclude that Douglass's dismissal of the scriveners was itself just politics, nothing more than an attempt to deny the slave power its constitutional camouflage. But as David's paper shows, in telling us how Douglass learned to read the Constitution, which in my view is the paper's signal achievement, there was so much more to Douglass's altered intellectual stance than politics. Douglass's dismissal of original intent and meaning from any authority over text substitutes a reading practice that is located not in historical time at all, but in what in March of 1849 he names a fixed principle of honesty, located at the ever-present now. True stability, he says, consists not in being of the same opinion now as formerly, but in a fixed principle of honesty, even urging us to the adoption or rejection of that which may seem to us true or false at the ever-present now. This is not a reading practice that is designed to produce, relativistically as it were, a new meaning for a new moment. It was one that engaged in a radically anti-historicist decontextualization of the Constitution that enabled Douglass to read the text strictly on its surface and to discover in it, as would he put it, a man from another country, an endless silence on slavery, a fugitive clause cast in language derived from institutions of bondage other than slavery, from apprenticeship, from indentured servitude, a 3/5 clause that counted those bondsmen for years among the free and acknowledged all others simply as other persons. Huang Fan has shown this was the reading practice Douglass was struggling to embrace in 1849. So again, I quote, "Suppose a man from another country should read the fugitive clause of the American Constitution with no other knowledge of the character of American institutions than what he derived from the reading of that instrument, will anyone pretend that the clause in question would be thought to apply to slaves? We think not. Nor would he dream of such an outrage, such a monstrosity on reading any other part of the Constitution. Blocked slavery from existence, and the whole framework of the Constitution might remain unchanged. There is, therefore, nothing in the Constitution which means slavery, only slavery, and nothing else than slavery. So, my position. So what, if any, is the significance of this reading practice for us? My friend, now at Stanford, Norman Spaulding, argued years ago, if the Civil War and Reconstruction represent, however reluctant it may have been, a second American Revolution, as Annette has suggested, modern American legal elites, since the Rehnquist Court, have been engaged in a very knowing counter-revolution, the results of which we see littered around us like rubble. One might argue that in Miller's lead opinion in Slaughterhouse, perhaps even, stretching a point, in Bradley's indulgence of a private taste for discrimination in the civil rights cases, the post-Civil War Supreme Court had the excuse of just sheer ignorance. In the court's fragility in the wake of Tawney, one might argue the court was attempting to find an accommodation between the fact of the Reconstruction Amendments and the culture of the polity that had emerged from the war. That is what I believe Pamela Brandwine tells us in her Rethinking the Judicial Settlement of Reconstruction, and it is a book I greatly admire and have learned a great deal from. But unlike the post-Tawney court, the Rehnquist court and its successors do not have the excuse either of fragility or of ignorance. They, just like us, enjoy the advantages of historical awareness, of hindsight. We know what the late 19th century did to African Americans, what the late 19th century Constitution did to African Americans, to the suffrage, the civil rights, the access to public accommodations, and on and on. In that light, the juridical counter-revolution begun in the later 20th century is a knowing and an uncaring counter-revolution instituted quite deliberately to exalt so-called first principles of federalism established in the original late 18th century constitutional settlement, while systematically diminishing what Norm called the plain exertion of national power over the states. That was the real outcome of Civil War and Reconstruction. And now we have the current court, a sort of agent of intellectual and practical chaos. For those of you who teach constitutional law, I feel your pain. It must be so hard to be a constitutional lawyer these days. The skill of stringing cases onto those golden threads of jurisprudential and doctrinal consistency, while the current Supreme Court continuously is grinding out new constitutions as fast as it can, as you try to explain the previous constitutions. David says there are 2 constitutions and maybe 3. Seems to me, and you referenced this, it seems to me there are hundreds of constitutions, maybe 1,000. The court generates one every day. One on one day, one on a different day, as suits its purposes. McGirt, one day. Castro Huerta, the next day. What is it going to do in Burkina? I have enormous fears for what this court will do in Burkina. The vital importance of First Nations people's control over their own children. I have a certain cautious admiration, I might say, for Neil Gorsuch in his First Nations jurisprudence. But read Gorsuch in the Yale Madero. He agrees with the rotten foundation of this case and then concurs in the outcome. I'm a fan of the Reduced Shakespeare Company. I don't know if any of you have come across the Reduced Shakespeare Company. I'm especially a fan of its version of Hamlet. Maybe, maybe not. Maybe not, says the Reduced Shakespeare Company in a perfect imitation, it seems to me, or a preconception of Gorsuch in that case. So under these kinds of circumstances, a man from another country, I suppose that's me, encountering lectures on the genius of the American Constitution, would most likely have a reaction rather like those of the United Kingdom's Brexit debates in the mother of all parliaments provoked, just like Brexit and the subsequent rapid-fire succession of flailing Tory governments. It would be funny. It's funny to watch if it were not so consequential, if it were not so consequential for so many people, if it were not so full of infamy and lies. This is the crazy bit, so bear with me. So this is because I'm really interested in Jacques Lacan, and so now you get a dose of Lacan. Once upon a time, lies and infamy that human beings inevitably produce as failing people, they were covered by God. God was there to complete humanity. Humanity's task was to worship God. God was awesomely indifferent to that worship because God did not need it to be complete. God was already complete. But God enjoyed the worship. It was also humanity's necessary response to God's glory, a way of acknowledging that God was indeed the acme of enjoyment that humanity craved for itself. And this God embodies what Lacan calls jouissance, the utter and impossible self-enjoyment of the complete. And this God died in the Enlightenment. But the death of God leaves an empty space, gaping, awful. So it demands attention. Produced a succession of totally inadequate replacements, filling the empty space created by God's death. The Enlightenment proposed humanity itself as the replacement. Kant proposed the categorical imperative. The state, the nation, on and on. Each place filler purports to confer a form of identity on human beings in the same way God once did. Each is a facile representation of our imagined completion, held up to us, a sort of God hologram that Lacan calls the big other. Now, in America, the Constitution is one of those inadequate placeholders, one of those human inventions created to fill the empty space left by the death of God. It, too, was an Enlightenment placeholder, a God substitute. Now, all God holograms, of whatever description they may be, they promise the deficient human subject, i.e. us, completion, just as the original version did in the promise of our reflection and completion in everlasting glory. They promise us our fulfillment, they promise us our own jouissance. And that is precisely why we create them. But they can never deliver on that promise because our completion is impossible, and because all the placeholders are just like us, and just like the original, they are creatures of language, which means they cannot heal our deficiencies because they are constructed from them. They share those deficiencies. We are condemned to language. We are condemned to its inadequacies. We are condemned to the slippage between signifier and signified, between the word and the thing. As Hegel puts it, the word is the murder of the thing. We may all have some familiarity with that lovely enigmatic observation of Derrida, il n'y a pas hors texte, which in Spivak's translation means there's nothing outside the text. Or in other words, there's nothing but language. One doesn't have to be quite so vulgar, because the phrase has other meanings. For example, it means also there is no outside text. Or in other words, that which is outside the text is not expressible in language. The inexpressible other is what Lacan calls the real. And by the real, he means that state of natural being from which we are all forever severed by our entrance into language. And language's inability to express one-on-one the essence of the thing, because the signifier can never reproduce the signified. This is the original cut, the necessary separation in which our self-consciousness is created. What we experience in life, that consciousness, is the symbolic order, ideology, by which I mean language and law, the order of language and law. This is the realm in which we live our lives. It's the only one we have. It's the realm of the cut, what Freud called castration, which is an unfortunate term to choose because its phallic connotation is unnecessary. What the cut means is our cut offness from the natural order. David's paper, and he referenced this as he spoke, David's paper contains a beautiful illustration of this. That sensitivity in his paper to Douglass's image of the blackbirds. But I want to ask precisely of what is that story and image? What does Douglass say? He says, I'm quoting David's paper, I used to contrast my condition with the blackbirds, in whose wild and sweet songs I fancied them happy. Their apparent joy only deepened the shades of my sorrow. Now, of course, this is offered as a conscious commentary on what it meant to be a slave. But slavery is a creation of language and law. It is an emanation of the symbolic order in which Douglass lived, which means to me that Douglass's commentary is not just a comment on his own enslavement. It is also a comment on all human separation from the state of natural being. Even a master of language like Douglass experiences the slippage between signifier and signified. His words cannot turn him into that wild, sweet, joyful creature he envies, no matter how profound his capacity to use words to communicate are. Douglass plumbs the realm of the symbolic order in which he and we are immersed. He does so in his own way, in part as an autodidact, in part as David puts it, the sponge that soaks up learning from others. And he comes to the conclusion that to comprehend this symbolic order of language and law that exists apart from the wild freedom of nature, only the text itself offered a standpoint with a degree of stability to hold on to. Not all the nattering and bickering about deeper intentions, whether doctrinal or social and empirical, not the mysteries below the surface of the text available only to those who appoint themselves cognoscenti, only the text itself, only the signifiers, only the words that declare themselves, because that is all we have. Our lives as academics largely is devoted to deep plunges beneath texts, to find what they really mean, to find the thing that must be explanatory somewhere deep down there. If only we can locate it, perhaps we can become blackbirds. Perhaps instead we should learn from Douglass, begin with the surface, begin with the text itself in the ever-present now, and begin with his fixed principle of honesty. I'm going to leave out the really crazy last bit, so.
Really, how it makes sense to go to this session, we have the opportunity then to speak to each of these wonderful individuals there. Please join me in thanking Blight, Professor Tomlin, for their terrific presentations.